So welcome everyone to Landmark Chambers webinar, Equality Law for Planners. We're delighted to see so many of you joining us today and hope you will find the presentations both useful and informative. My name is Jenny Wigley QC and I will chair the session today, joined by my colleagues Alex Goodman, Alex Shattock and Kimberley Ziya, whom I will formally introduce to you in a moment. To begin with, a few housekeeping matters, most of which I'm sure you're very familiar with. Your microphones are automatically muted, so you don't need to worry about your local settings. We very much welcome questions throughout the webinar, so please submit them via the text on the Q&A section, which is either at the top or bottom of your screen. And if you would like to remain anonymous when asking a question, please make sure you tick the send anonymously box before putting in your question. We'll endeavour to answer as many of the questions as possible today at the end of the presentation. However, if we can't get to them all, we will endeavour to follow up after the event. The webinar is being recorded and you will receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point during the webinar, just rejoin the meeting by clicking on the original link once more. So let us begin with some introductions. First, Alex Goodman, he was called in 2003 and his practice encompasses public law and planning, and he acts for all parties in the High Court and inquiries and beyond. In terms of his work of particular relevance to today, he's acted for gypsies and travellers, local authorities and developers on a range of planning matters. And he is currently instructed on a judicial review of a planning permission for an immigration detention centre on grounds of a failure to discharge the public sector equality duty. He has particular expertise in discrimination and is on the Equality and Human Rights Commission's A panel of counsel. And earlier this year, he was awarded the Legal Aid Lawyer of the Year Outstanding Achievement Award 2021 for his work on denial of benefits to immigrants in claims alleging discrimination, breach of human rights and breach of the best interests of the child. Alex Shattock, he has a mixed public and planning law practice and often considers equality duties and issues in both of those areas. He was instructed by the claimant in the Rights Community Action case, a challenge to the new permitted development rights and Class E, which included a public sector equality duty challenge in the divisional court. And that case, as I'm sure some of you are aware, is currently in the Court of Appeal waiting judgment, I think. He's been led by Alex Goodman in several planning challenges to asylum accommodation centres that involved equality and segregation issues. And he has experience advancing equality arguments at planning appeals in support of developments that offer equality benefits, such as building a new state school in the deprived inner city area. Last but not least is Kim, who has a varied practice covering all aspects of planning, environmental, infrastructure and procurement. And she also has property expertise, which makes her very well suited to advising on the various crossover issues that arise out of developments. She acts for developers, local authorities and local interest groups at both inquiries and in the High Court. And in a case against me, Kim was recently led by Sasha White QC for the developer in an 8-day public inquiry concerning the demolition of existing airy houses and construction of 17 new homes as their replacements. The issues in the appeal included the application of the public sector equality duty, the best interests of the child, and the existing residents' rights under landlord and tenant legislation. So without further ado, I will hand over to Kim, who will speak on the requirements and application of the public sector equality duty in the planning context. So Kim.
Thanks very much, Jenny. As Jenny said, I'm going to be talking about the public sector equality duty, what it means and how it applies in the planning context. And so in brief, my talk's going to start by going through what exactly the public sector equality duty is and what it entails. I'm going to go through a few very brief examples of how that's been applied in the planning context and cases in which that might arise, and then summarise with a few practice points for decision making that might involve the public sector equality duty. So turning on to the duty itself, For duty, the source of a duty is at section 149 of the Equality Act 2010, as I'm sure many of you will know. However, it's quite a dense section, and therefore I think it's worth unpacking a little bit at the start of this webinar. The first thing to note from the section that you have, the subsection that you have there on the slide, is that this is a mandatory duty. It's something that public authority must do when exercising its functions. And that's the second point to note. This is something that applies to public authorities when exercising any of their functions. Thirdly, and we'll return to this at various points during my talk, and no doubt in the other talks that are to come, that this is a duty to have due regard to the specified statutory aims. So it's not a duty to reach a particular result, but that have due regard is the real essence of this duty. Fourth, you have the three aims themselves, and you can see that they're each slightly different, and they're approaching the issue from a slightly different perspective. The first one I like to think of as a sort of curative aim, so it's trying to deal with existing discrimination, harassment and victimisation, and trying to tackle existing problems. But you then have the two more preventative and forward-looking sort of positive aims of actively advancing equality of opportunity and seeking to foster good relations between those with protected characteristics and those who do not have them. And finally, that this duty applies both to a person who is a public authority, but also to those who are exercising public functions. And just a little bit on that, if you look to section 150, that tells you to look to schedule 19 for what is a public authority for the purposes of this act. It's a fairly particularised list, and it specifically includes county councils, district councils and parish councils. Whereas the exercise of a public function is defined by reference to the case law under the Human Rights Act 1988, which is potentially much wider, so worth bearing in mind. In any event, what's clear is that the duty will apply to those making decisions at all stages of the planning process. So from local authorities when they're plan making to when they're decision taking to inspectors and beyond, and all the way up to the Secretary of State setting national planning policy. So one that is going to arise at various different stages in the planning context. So turning on to the next part of the section, it tells us a little bit more about what the second and third of the statutory aims mean, and starting with the second one being the need to advance equality of opportunity between persons who share a relevant protected characteristic and those who do not. And it tells us that this involves, so it's not a comprehensive list, there may be other things that are relevant to this as well. It involves having due regard, in particular, to the need to remove or minimise disadvantages that are connected to the protected characteristic itself, to take steps to meet the needs of persons who share a protected characteristic that are different from the needs to persons who do not share it, and to encourage participation in public life or other activities in which participation by persons with protected characteristics are disproportionately low. So the thing to note from this is that this duty is all about identifying where people with protected characteristics have a different experience or are treated differently or have different needs to those who do not. And that's the key for this duty. It's not just anything where people with protected characteristics are affected, but how are they affected in a different way to other members of society who do not have those protected characteristics. And I would note also again that this is a positive and proactive duty. It's not just about removing disadvantages or prohibiting development that might have specific disadvantages. It's also about actively trying to meet needs, actively trying to encourage participation in areas of life where that participation is disproportionately low. So there's both positive and a negative limb to this aspect. And then what you have in subsection 4 is a very specific requirement where the needs of disabled persons are engaged, and namely that's taking active steps to account for the disabled person's disabilities and specifically taking that into account. So moving on then to the third of the statutory limbs, and this is the need to foster good relations between persons who share protected characteristics and those who do not. Again, you see that there's both a curative and a preventative aspect to this. So you've got to tackle any prejudice that exists or any prejudice that might arise, but you've also got to try and promote understanding and try and remove and prevent prejudice from arising in future. And then finally, you've got subsection 6, which tells you that you may have to treat some people more favourably than others. I mean, that's most likely to be people with protected characteristics, potentially more favourably than those who do not have them. But in doing that, you have to be careful not to effectively end up discriminating against perhaps another group of persons who have protected characteristics. And this is particularly important in circumstances which often arise, and we'll come onto it in some of the examples, where there might be a tension between the needs of one group of people with protected characteristics and another. Alex Shattock, for example, I know is going to talk about designing for equality in toilet provision in particular is an area where there's potential to affect various different persons with protected characteristics, from sex, gender, disability, and assisting one or putting the needs of one group forwards may have another effect, a disadvantageous effect on another group. And so you need to be very careful in how you're balancing those potentially competing needs. So that's what the duty requires. So what are the protected characteristics? Finally, on section 149, they're set out in subsection 7. So you've got age, disability, gender reassignment, pregnancy and maternity, race, religion or belief, sex and sexual orientation. And you've got a little bit more detail on each of those protected characteristics at sections 5 to 12 of the 2010 Act. So having looked at the statutory provision itself, what does this actually mean in practice? And I direct your attention here to the decision of Mr. Justice Lindblom, as he then was in the Coleman case, particularly at paragraph 65 to 71. And he tells us that there's a vital distinction between a duty to achieve a particular result and a duty to have due regard to the need to achieve some statutory aims. So that's very important given the nature of these statutory goals. You're not going to eliminate discrimination in all forms through one decision, but the key is that you're having regard to the need to do that and making sure that you take all reasonable steps within your abilities when reaching a decision to try and make sure that the decision works towards rather than undermining that particular goal. The second point to take away from this is that it's a question of substance, of course, rather than form. So has the decision maker in substance had due regard to the relevant statutory aim or the relevant statutory need? And you'll see from the case law examples that we're going to come on to, but simply saying that you've complied with the duty clearly isn't sufficient. But equally, you can comply with the duty without necessarily spelling out that you've looked at it. Although my recommendation would be that you always do, if you are dealing with a case that gives rise to the duty, that you do specify that that's what you're doing. Turning then to this due regard, which is obviously the essence of this duty, what does that mean? Well, due means the regard that's appropriate in all of the circumstances. And this is a classic question of judgment for the decision maker. And it might be that simply saying that the statutory goals are engaged might be sufficient in one case, whereas in another case, it might require a full-blown equalities impact assessment, or it might require the decision to be refused rather than just giving weight to a particular aspect. So it's really going to depend on the circumstances of the case. What are those circumstances? Well, Mr. Justice Lindblom tells us that they include the importance of the areas of life of the members of a disadvantaged group that are affected by the inequality of opportunity and the extent of that inequality. And they also include such countervailing factors as are relevant to the function which the decision maker is performing. So an example which we'll come on to is that there might be a difference between the factors that are relevant or what due regard requires, where a development would not do everything it could to make access better for disabled people versus a development that would actively take away access for disabled people. That's having a different effect in terms of the equality of opportunity that is being that is arising from development. In both cases, statutory goals are engaged. In both cases, the duty will come into play, but the circumstances are different, and what due regard requires might be different in those cases. As for countervailing factors, that's anything that would be a material consideration in reaching a public law decision. So it's economic and practical factors, but also other social and public benefits that could involve, for example, environmental issues and weighing those against the statutory aims. And one final point here, which really goes without saying, is that this has to be an integral part of the formation of a decision. It's not a tick box exercise, and it's not just a reason for refusing or granting permission. It has to feed into your decision-making process. And that's very important for how you set out your reasoning in cases where the duty is engaged. And finally, specifically in the planning context, because Coleman was a case in the planning context, again, Mr. Justice Lindblom notes that the duty will arise in a wide range of circumstances, and you have to and that different circumstances will lead to different factors being more important than others. So you could contrast the decision of a local authority, which is having to decide whether or not to withdraw a particular public service due to budgetary constraints. That's a very different context to a local authority determining whether or not to grant planning permission. However, and this is stressed in the decision, it's important to remember that it's not that the duty is less onerous or less important in the planning context. It's simply that the circumstances are different, and that therefore there are potentially different countervailing factors at play, and what due regard requires might be different in that different context. I'm just going to touch on a few examples, but quite high level, because I know that Alex Goodman is going to come on to some of these in a bit more detail, or some case law examples in a bit more detail, and I'm conscious of the time. But here are a few examples of where a decision maker got it right, where issues of public sector equality duty were engaged in the planning context. Baker was a case where involving planning permission, well, an application for planning permission for members of the traveller community to pitch caravans on a site in the Greenbelt, and the inspector, considered that the loss of considered the public sector equality duty without expressly referring to it, but he had weighed up all of the necessary factors. In Coleman was a decision about development of a school on land where a garden centre had previously been situated, which was regularly used by the disabled and the elderly. And this is quite a good example of the potential tensions that can arise between different groups of people with different protected characteristics, so school children versus disabled and elderly people who were using the garden centre. Nonetheless, the decision maker in that case managed to properly balance those different needs and reach a lawful decision. In Lakenheath, this was an interesting one involving a school that was being built very near to a military airfield, and the effect of the noise the noise would have on pupils, and whether the decision maker had properly taken into account the different effects that it might have on different pupils, depending on their particular characteristics. And then just a couple of examples where the decision maker got it wrong, and if you want to see what that looks like and what to avoid. So the LDRA limited case was about planning permission for building an office and warehouse over an existing car park, which had been regularly used by disabled people to access the riverside. And the problem here was that while the inspector did consider the loss of the car park and the public access to the riverside, he considered that it would just make it a bit more inconvenient for people to access it. And what he completely failed to do was to look at or consider the evidence that it would actually be impossible for less able-bodied people to access the riverside, and therefore the decision was unlawful. And the fact that this wasn't a main issue in the appeal, in the inquiry or in the appeal process, didn't matter. It's still a decision. It's a legal duty on the inspector that he had to take into account. And finally, just an example of where it might arise, perhaps in a slightly surprising context, is in Danning. This was a grant of planning permission for a pub to be converted into a residential dwelling, and the decision maker hadn't even considered whether removing a pub, which is effectively a community facility or a community service, might have particular impacts on those with protected characteristics, and therefore hadn't considered any of the implications for the statutory aims in section 149, which rendered the decision unlawful. Another good thing to note from this decision is it really shows that ex post facto evidence is unlikely to help you here. So coming back after the event and saying, oh, well, we did take this into account. If it's not clear in your decision that you did, then you will often be, then the decision will be unlawful. So finally, where does that leave us then in terms of sort of practice points going forwards? What I would say is, I would suggest sort of taking the following very high level structure when you're dealing with these kinds of decisions. So ask yourself, is there any evidence that the decision will impact on those with a protected characteristic? If there is, then the duty is clearly engaged. But the other thing to note is if you suspect that there might be impacts, but there maybe isn't sufficient information for you to determine that, then you need to ask for it. And the LRDA limited case is quite specific on that point, that the inspector should have sought further information if he didn't feel that he had sufficient to make the decision that he needed to make and apply the duty properly. The second point is to go through the statutory aims in section 1491 and decide whether the decision that you're going to take would promote or undermine these aims. Both are relevant. If it's going to promote the aims, then that's going to be potentially weighing in favour of a decision, and if it's going to undermine it, then that's a factor weighing against it. Remember to think about what due regard entails. It's ultimately a matter of judgment, but you're going to need to show that you've reached a judgment and why, and that that's a reasoned judgment. There's obviously a wide spectrum. Withdrawing a public service is going to be different to not maximising the potential to advance equality of opportunity, but you need to think about how the factors are engaged and what due regard is going to entail in your particular situation. And then finally, taking into account countervailing factors. What other factors are reasonable and material considerations for you to take into account in reaching this decision? The weight is obviously, again, a matter for the decision maker and very unlikely to be successfully challenged as long as you've explained what weight you've given and why. So that's a very quick run through the public sector equality duty and how it applies in the planning context. I'm going to hand on now to Alex, who might delve into that in a little bit more detail. Thanks very much.
Hello, everyone. My talk's going to cover the main provisions of equality law, which planners need to be aware of, and it's going to highlight how they've been applied in some of the recent planning cases. It's not supposed to be exhaustive of every case, but hopefully sets out the main issues. And I'll consider first the provisions on discrimination, which are engaged in the planning context, before exploring their application in some of the planning cases, particularly the more recent ones. I'll then have a look again at the public sector equality duty, just further to Ziya's talk, since that's proved to be the most significant part of planning litigation in the discrimination field in recent years. The domestic framework for discrimination is now largely governed by the Equality Act 2010. And that prohibits both direct discrimination and indirect discrimination. So section 13 of the Equality Act provides that direct discrimination entails the treatment of a person less favourably than others because of that person's protected characteristics. The protected characteristics include age, disability, gender reassignment, marriage and civil partnership, pregnancy, race, religion or belief, sex and sexual orientation. In the planning context, the whole range of those is relevant. Probably most of the case law focuses on race because most of it arises in the gypsy and traveller context. Indirect discrimination is governed by section 19. And section 19 provides a complex, well, seemingly on its face complex understanding of the concept of indirect discrimination that's found across discrimination law over the last 40 years. The way section 19 applies it is that one has to identify what section 19 calls a provision, criterion or practice, which is shortened to PCP, which has the effect of treating people with a protected characteristic less favourably than others. So you have one group treated less favourably, one group treated more favourably by the provision, criterion or practice. Unless the PCP can be shown to be objectively justified, it will amount to indirect discrimination for the purposes of the Equality Act 2010. When a claimant raises a prima facie case of discrimination or any other breach of the 2010 Act, there's a specific provision in section 136 of the Act, which provides that the burden of proof shifts to the defendant. So the way it's framed is section 136 says, if there are facts from which the court could decide, in the absence of any other explanation, that a person A contravened the 2010 Act, the court must hold the contravention occurred. But if the defendant can discharge the burden on him, then it doesn't apply. Article 14 of the European Convention on Human Rights is the other discrimination provision. and that is incorporated obviously into the UK's domestic law through the Human Rights Act 1998. Article 14 doesn't stand on its own. It always has to be read in conjunction with one of the other rights in the Convention. In the planning context, that is usually Article 8 of the European Convention on Human Rights, or Article 1 of the first protocol to the Convention, which Article 8 is the right to a private life, home and family, and Article 1, Protocol 1 is the right to enjoyment of peaceful possessions. Sorry, peaceful enjoyment of possessions. Article 14 prohibits less favourable treatment of persons in analogous circumstances unless it is justified. So that's a summary of the extensive case law on the provision. So I'll turn to look at some of the cases in context. Direct discrimination, first of all. So this is section 13 cases. There's not a lot on this in the planning world, but this case, Fraser against Shropshire Council, did raise an allegation of direct discrimination in relation to development of residential accommodation for older people. The claimant argued the council had directly and indirectly discriminated on grounds of age or disability by permitting the development to provide less open space than it would have required for a development serving younger and able-bodied people. The court found no discrimination had occurred in that case. The court said the officer's report was sound in concluding that despite failing to provide the amount of open space ordinarily required, the quality of the open space made it a better development proposal, irrespective of the intended residents of the development. So permission, therefore, would have been granted whether the intended residents were older people or not, and the court held no discrimination had occurred. Next case is Secretary of State for Communities and Local Government against Proudfoot Properties, which went to the Court of Appeal. The main judgment's actually in the High Court, but I've cited the Court of Appeal. This case was primarily a reasons challenge, so saying that the inspector had not set out adequate reasons for his decision. The applicant for planning permission had sought planning permission to develop 6 houses with triple garages in an area of outstanding natural beauty. And he contended that as planning permission had been granted for similar proposals in the area, the council discriminated against him, contrary to Article 14. Mr. Justice Lang held in the High Court that the inspector was entitled to conclude that safeguarding the A&B was a legitimate aim, i.e. it's proportionate, it's justified, and therefore, and that refusing planning permission was the minimum necessary way of achieving that aim. So as to Article 14 discrimination, the court held that the comparator cases the applicant relied on presented different considerations, and the clear harm his application presented to the A&B justified refusal. And the Court of Appeal upheld the decision of Mr. Justice Lang. Next case is called Smith against Secretary of State, Communities and Local Government. Smith is about the definition of gypsies and travellers in a 2015 revision to government policy. It's one of many cases by gypsies and travellers alleging less favourable treatment on grounds of race. The policy called Planning Policy for Traveller Sites 2015 created a more permissive planning regime for the development of gypsy and traveller sites, but amended the definition of gypsies and travellers to persons who live a nomadic way of life. And that amended a previous definition, which included those who had ceased their nomadism and settled. The 2015 policy could not apply to applications made by settled gypsies and travellers. Instead, their applications were governed by the more restrictive conventional planning policies. And the claimant argued that this definition unlawfully discriminated against elderly and disabled gypsies and travellers, contrary to Article 14, read with Article 8, as you always have to read Article 14 with one of the substantive articles, and contrary to Section 19 of the Equality Act 2010. The Secretary of State accepted the claimant and her family were at a disadvantage vis-a-vis nomadic gypsies and travellers, but the court considered there was nothing inherently objectionable in making provision for the development of sites for nomadic gypsies while accommodating the needs of settled gypsies and travellers elsewhere in the planning system. The 2015 policy was a proportionate means of achieving a legitimate aim. Next, provisions or discrimination provisions have been used to challenge the implementation of planning policies. Interesting case called Moore. Under the government's 2012 planning policy for traveller sites policy document, the development of traveller sites in the green belt would only be permitted for exceptional circumstances. And in ministerial statements, the minister stated he would consider recovering appeals concerning development of traveller sites in the green belt. Now, the Secretary of State's policy said that not all such appeals would be recovered, but in practice, the Secretary of State did recover all appeals in respect of traveller sites on the green belt between September 2013 and September 2014. And the claimants successfully argued that this practice, not the policy, amounted to indirect discrimination, contrary to Section 19 of the Equality Act 2010. Mr. Justice Gilbert found that although the policy for recovery was not itself discriminatory, the application of the policy was discriminatory within the meaning of Section 19, as the appeals take longer to determine than appeals made by people who aren't travellers. And so this approach was not a proportionate way of achieving the Secretary of State's legitimate aims. There was no appeal in Moore, but there was then a case called Connors, which picked up a similar theme. Connors, the appellants argued that if the practice of recovering all appeals in relation to development of gypsy and traveller sites constituted indirect discrimination, and alleged the Secretary of State's decisions in those appeals were unlawful. So the actual decisions on whether to grant planning permission were unlawful, not the practice of recovering them. But the Court of Appeal rejected that argument, holding that even if the Secretary of State's recovery decisions were a breach of equality law, so the decision to decide them himself, the appellants would still have to show that that unlawfulness then went on to infect the decision-making process itself. And they failed to do that. And the only route to challenge the decisions was on public law, conventional public law grounds. So that's a run through some of the cases on discrimination under Section 19 of the Equality Act, Section 13 of the Equality Act, and Article 14 of the European Convention on Human Rights, read with Article 8 and sometimes with Article 1, Protocol 1. So then the other big area that Ziya has already looked at is the public sector equality duty. So I'm just going to skim through that as well. Section 149. Ziya's been through the provisions, so I won't repeat them, but they're there on the slide. Section 149.3 sets out the provisions to which one must have particular regard. And the basic requirement, the case of Buckley I've cited, is the real issue is whether the relevant public authority has in substance had regard to relevant matters. It's a fairly straightforward summary of the duty. And then some of the cases. We've got the Buckley case. That was a case about partial demolition and rebuild of an estate. No regard was had to the impact of the demolition on elderly residents. While there was a rehousing policy, there wasn't an assessment of the needs of particular groups or the impact of demolition. And no regard in particular was had to the elderly residents and the impacts on them. So the outline permission was quashed. The Danning case, Ziya's talked about, error of law in failure to fulfil the duty in relation to change of use of a pub. Simply no consideration was given at all, so the decision was quashed. Williams, successful challenge to closure of a leisure centre. The claimant alleged that in making the decision to close the centre, council had no regard to the impact on elderly and disabled people. LDRA Limited, Kimberley referred to that. Court wasn't satisfied, and the inspector had had any regard to the impact on disabled people of loss of car park and access, so permission, access to a river. So permission was quashed. And then I've included a few less successful cases. Gathercole, It's quite salutary because in that case, the Court of Appeal held that when considering planning application to build a new village primary school next to a military airfield, the local planning authority had failed to have regard to the effect of aircraft noise on children with protected characteristics. That did breach the public sector equality duty, but no remedy granted, because applying section 31(2)(a) of the Senior Courts Act 1981, it was highly likely that the same decision would have been made without the error. And that's a pretty common defence these days, so you have to be quite careful of that in bringing claims. Lake and Heath, decision to grant planning permission for primary school was upheld because the duty was discharged in substance, even though there wasn't express reference to it. Coleman, claim under section 149 dismissed because the council had done everything required. And my final note is that there are cases that go back to section 71 of the Race Relations Act, which was a predecessor provision, which are relevant to consider in this context. So I've listed some of those. My basic view is that the discharging the PSCD requires, in essence, asking the right questions as to what the equality impacts are, taking measures to ascertain the factors relevant to answering those questions, and then showing some evidence of substantive consideration of those factors. The courts are not prescriptive of the form required for that process, as long as, and even the duty doesn't have to be explicitly referenced. But where no consideration at all is given or it's wholly inadequate, the court is willing to grant remedies in respect of planning permissions. Thank you very much. I'm going to pass to Alex Shattock for his talk on designing for equality and best interests of the child.
Great, thank you, Alex. Hello, yes, my name is also Alex, and as you can see from my photo, lockdown has not been kind to me. We are slightly behind time, so while I will try and be quick, if you need to rush off at 12 while we're still answering your questions, we won't be offended, I promise. So I'll be talking about two distinct topics: designing for equality and the best interests of the child. Getting right to it, you might think designing for equality, both at the plan making stage and the project stage, it's a tricky thing to do. But my response, in short, is it's important, but it isn't that difficult. It's largely a case of being alive to the issues and giving them proper consideration. And as a starting point, there's some very helpful guidance out there, which I'll put some links to on this slide. And I understand that this will all be shared later to participants, so no worry to take it all down. So I'll start first with the plan making stage. I'll just give you a flavour there of some of the things we might need to consider. You'll see first we have the age of consultees. I'm sure you'll be aware it's almost always older. Young people don't tend to respond to consultations as much. Presumably they're busy watching Power Rangers or playing on their Tamagotchis, or so I'm told. So your consultation responses on the question of, say, should we get rid of the skate park and replace it with a tea room, will quite possibly be skewed in a particular direction. This problem, though, emphasises an important requirement in any equality impact assessment: data. You need to know who is in your community, what is their makeup, what issues do they face, and of course, what are their opinions. And you might not get any of that through the usual channels. So my suggestion would be try and engage young people, indeed a wider spread of people from the usual suspects with your consultations. Use social media, maybe even tell a few jokes. Maybe it will engage people a bit more. Doesn't usually work for me, but you might have more success. We could have a long conversation about travellers as well, but the key point is a lot of these equality cases are about travellers, and you should think about equality issues very carefully in any decision that affects them. Not everyone has or should have the same lifestyle, and different lifestyles need to be accommodated. Finally, just another example on this slide. When you're designing a plan, ask yourself, are you putting all the nice things in the nice areas? Because if you are, then that can help entrench, for example, racial division. And there's a chap there called Robert Moses from New York. He had a particularly blatant policy of hardly any parks in Black majority areas, nowhere for the children to play. And in inequality terms, that's obviously appalling. Just to summarise, then on the plan making stage, do your assessments, get as much data as you can, identify the issues, and then have policies in place to address those issues. And that should help protect your shiny new plan against any statutory challenge on the basis of, say, PSED. So that's plan making. What about buildings? And this came up in an inquiry I did recently. A big development in a flood zone, high level walkway to escape in the event of a flood. But what about people in wheelchairs who can't get on to the walkway? So firstly, you need to do your best to make sure they can get onto the walkway and that escape routes are accessible. And only if that's not possible, then you need to build in something else. For example, refuges, places of safety. It's about planning for the fact that not all the residents in your developments will be able-bodied. Another issue, what if you're planning to take away something that might be described as an important equality benefit? And we heard some of this in Kim and Alex's talks. So say you're demolishing the skate park, but it's mainly used by ethnic minority kids, for example, and they have nowhere else to go for 10 miles. What are you going to put back in to your development for them to make up for that equality loss? And just following on from that, the final point, we shouldn't just be trying to break even on equality. We want to actually see some gains, as my personal trainer likes to say. So if you're offering, say, a community centre, a tea room that can be used by older people, a library with free internet facilities that can be used by disadvantaged groups, all of that before committee and indeed at appeal can properly be characterised as an equality benefit, which the decision maker will need to take into account, will need to weigh in the balance in your favour as part of their public sector equality duty, as part of their equality considerations. So I would say, if you're developing these sort of projects, put equality gains on the table. It's a win-win. So for the next few slides, I'm going to talk about toilets. I'm not going to lie, this is not the sexiest topic I've ever presented on, but it is a very important one. So when you're putting in the loos, increasingly, you will need to think about this kind of stuff, equality. So first, gender-neutral toilets. The Mayor of London actively encourages them in planning policy terms. By contrast, earlier this year, the government said it would regulate to discourage them. So that's all very helpful. And obviously, the one thing planners love the most is getting involved in toxic culture war debates that pit two disadvantaged groups against each other. But that is something, regrettably, you may need to navigate when you're designing your buildings. Personally, I think the way we do it at Landmark is pretty good. We have mainly gendered loos with one gender-neutral loo per floor. Not a bad way through the political maze, but there are different ways to do it and no obvious one-size-fits-all approach. But it's just important to bear in mind all the issues. And again, if you give something to one group, are you taking something away from another group, even arguably? Second, consider putting in more female loos than male loos. I don't think I need to explain why the gender disadvantages we see on a daily basis in that regard are pretty stark. And third, obviously, baby change facilities. Strictly speaking, having a small child is not a protected characteristic, but if you have one, I suspect you might think it should be. So definitely just consider all that as part of the same package you're offering. Next, we have a new requirement, very important. It's called changing places toilets, if you haven't heard of these. And these are loos for seriously disabled people who struggle in public places because there is nowhere they can easily go to. So these loos provide the right amount of space and the right equipment for, say, carers to assist. And you can see an example picture there of what this might look like. Now, changing places toilets are mandatory now in many large buildings under Proof Document M of the building regs. So we're talking about shopping centres, sports halls, hospitals, exhibition centres. So again, something to bear in mind if you weren't aware. But again, just because they're not mandatory in other contexts doesn't mean you can't put them in anyway. So, so I would say, be a trailblazer. Think about disadvantaged groups who might be using your developments, and put those changing places toilets in. I had to include this. I've just summarised the previous section as follows. If you think carefully about lose, you can't lose. So that's designing for equality. Now we have best interest of the child. You'll see there just a playful little white paper joke there. We're all friends here. Best interest of the child, not equality law proper, but I would say adjacent importance often comes hand in hand with it. And most of all, you need to know it. And that's because planning decisions like all political decisions, need to have regard to the best interests of children. All started with this immigration case, ZH Tanzania, that was applied in a planning case by Mr. Justice Hickinbottom, a judge who I understand is now in the Caribbean, probably having a great time. But what he said was, in Stevens, he gave a sort of structured approach to how we should deal with the best interests of children in the planning context, later endorsed by the Court of Appeal. So firstly, the key thing is you need to identify what a child's best interests actually are. And if you struggle with that, they'll probably be those expressed by the child's parents. So the child does not need to be cross-examined by the appellant's QC, thankfully. And then we see the child's interests are a primary consideration, that's what they have to be. And that should really be your wording, actually, if you're writing up a committee report or a decision letter. You know, a child's interests are a primary consideration in this case. However, that doesn't mean they have to be an overwhelming, overpowering consideration. They can be outweighed by other considerations too. There is a balance. So primary consideration 1, child's best interests, can be outweighed by a combination of, say, considerations 2, 3, and 4. There's nothing wrong with that. As long as the child's interests have primacy, they've got to be at the forefront of your mind as a decision maker. And as long as that's the case, then perfectly entitled to consider to find that other factors outweigh the best interest of the child in a given particular case, as long as you've got it at the forefront of your mind. Just a legal footnote on this slide. Stevens was an Article 8 case. What about non-Article 8 cases? While the Court of Appeal in Collins says best interest of a child applies to any decision concerning children. So it doesn't have to be, they don't have to be Article 8 issues for it to be something that should be at the forefront of your mind. Earlier this year, we made a point at appeal when we were trying to redevelop a city centre with a new state school, and the best interest of a child obviously apply in respect of the school. So we made some quite detailed submissions on that for the appellant. Just to wrap it all up then, quality law may seem worlds apart from planning law, but like two equally massive celestial bodies, they are slowly but surely pulling themselves into each other's orbit. In other words, you need to know this stuff. It will only be more important in the future. If you're looking to get something built, you want to carry out all your equality assessments, basically bomb-proof your decision from a PSED challenge. And if you're looking to stop something getting built, pay close attention to the equality issues because they're often not given the time they deserve and need in decisions, which is a promising ground from a judicial review point of view. Right, that's the end of my presentation. I think we'll all be coming back on now, won't we, Jenny, to answer some questions.
Yes, thanks very much, Alex. Thanks, everyone. That was really informative and helpful, and I hope interesting to everyone. It seems to be, because we have had quite a few questions. So we haven't got that much time. We'll seek to answer as many as we can, and if we do go over 12 o'clock, I hope some of you at least can stay with us, and there'll be a recording anyway, so you can catch up afterwards if you can't. So first question for Kim, I think, Kim. What happens if the local planning authority doesn't give the public sector equality duty or any issues relating to that as a reason for refusal when refusing planning permission? The application is then, the refusal is then appealed to an inspector. How is that then dealt with? Are the local planning authority able to raise it, even though they haven't made it a reason for refusal? Is anyone else able to raise it? And what should the inspector do about it?
So I think this comes back to one of the decisions that I talked about in my talk, and I think Alex touched on his. I mean, it's the fact is it's a legal duty that's on the inspector, whether or not it's a main issue in sort of in planning terms. I mean, it clearly should probably be recognised as a main issue if it arises, but if it's been missed for whatever reason, then the inspector needs to have enough information in front of them to deal with it. And that's something that the inspector needs to address. So both for a developer, an appellant, and a local authority, and any Rule 6 party in that kind of appeal, you need to be thinking about what information does the inspector need to be able to discharge their legal duty. It's parallel, for example, with heritage type legal duties that an inspector might need to consider, will need to just consider whether or not it's in dispute between the main parties. They still need to have enough information to discharge it.
Yeah, exactly. So it would be foolhardy, I think, for a developer to ignore it or try and push it away, because they then might have a decision which is vulnerable to challenge. So Yeah, agreed. We've had a question also about the interaction between the public sector equality duty and the duty to make reasonable adjustments for disability issues. I think, who wants to answer that? Alex Goodman, did you want to answer that? Need to unmute.
Yeah, I was going to type an answer and I pressed the wrong button, so I'll just quickly summarise what I was going to say. The Section 149 duty is much broader than the reasonable adjustments duty, because it relates to a requirement to have regard to all the equalities impacts and all those considerations that are set out in Section 149. So insofar as they relate to fostering good relations between communities, but it's not just about disability, it's about age, race, sex, etc. So that's the first point. And then insofar as the two do both relate to disability, the Section 149 duty is essentially just a procedural duty to have due regard, whereas the reasonable adjustments duty requires, in some cases, actual measures to be taken. Obvious examples like ramps to buildings and so on, so substantive measures. So that's Section 20 of the Equality Act is where that's set out. So that's the main distinctions between the two.
Yeah, I think it's positive steps in specific areas, isn't it? Like in buildings or in education settings or the like, to actually, and I suppose that's more to achieve a positive result rather than just to have regard to all the protected characteristics. Yeah. A few specific questions about where possible things fit in with protected characteristics. One thing that Alex Shattock mentioned is baby changing facilities, and whether that might fit in, how that would fit in under protected characteristics. My view, Alex, is wouldn't that would potentially fit in under maternity, would it, or be relevant to age? What are your thoughts on that?
Yeah, absolutely. I think a comment in the chat that made a very, very good point that, it certainly could be relevant to age. So I suppose you'd either bring a general PSCD challenge from someone with small children, or you'd bring a direct challenge on behalf of the child themselves, I suppose, for litigation friend. But yeah, no, I can certainly see how an age-related challenge.
One of my bugbears is that I find it quite incensing that where baby change facilities are only in the women's toilets, on the assumption that it's just the women who have to change nappies. So I think I'm not sure how that will be dealt with legally immediately, but it's certainly something I think that people should bear in mind, not to just assume. Okay, another issue, menopause issues, which is having much more public attention. How would that fit in to the public sector equality duty and the protected characteristics? I mean, presumably that would be an aspect of sex, wouldn't it? And definitely should be taken into account in that respect. Yeah, okay. Alex Goodman, you mentioned this issue particularly about the increasing defence of using the Senior Courts Act wouldn't make a difference, or highly likely it wouldn't make a difference, as a basis for not providing a remedy even when there has been a breach of the public sector equality duty. From your experience, how would you say you can seek to persuade the High Court that it's not just a technical challenge and it is a challenge that requires a remedy?
Yeah, I think if you're acting as a claimant, one of the important things is to not go too overboard on the law. The courts are getting rather bored of lengthy explanations of really what's a very straightforward public law duty to inquire into what the equalities impacts are, make sure you get some evidence to answer the questions that are posed and to have due regard to them. It's not that complicated in legal terms what's being asked of you. It's just making sure that equality issues are considered. So really focus on the substance, don't focus on lots of case law. I think that's the important thing. And then of course you have to close off how that would make a difference if the decision were reconsidered, because if you don't put evidence and pleading in on that, then that's an obvious point to take for defendants.
Yeah, so I think you have to give the real world impacts of what that decision, by ignoring that aspect, what that decision has, who that decision can potentially affect and how that might have been avoided if it had been addressed. What about how the trends in this. One question we've been asked is how important are equality law issues going forward going to be, do you think? Probably a question for Alex Shattock, looking at the future. Do you think this is something that's going to increase in prominence or decrease?
Yeah, absolutely. I think the courts are increasingly interested in equality, and on best interest of the child as well. We know this applies to all planning decisions. Reasonably recent clarification on that. There's no reason why you can't put it in as a ground of challenge and argue the case. I've certainly seen more and more of it, and unless and until the Equality Act is repealed, I think we're going to see more and more of it as well. Yeah.
And again, I think one question we've been asked particularly about how the equality duty, public sector equality duty, affects plan making. If local authorities do not assess emerging policies on the basis of that, both the duty and the anti-discrimination requirement, what do you think is the legal consequence of that? And how careful do local authorities need to be in terms of not just making a sweeping statement that it's been considered, or actually setting out their reasons in relation to each protected characteristic? Anyone have thoughts on that?
So the duty, there's a number of questions that are similar actually in the questioning on this. Explicit reference isn't required, but obviously it's sensible. What is required is rigorous consideration of the substantive issues raised under the public sector equality duty, and so that's what should be undertaken, and that should be done with an open mind and addressed to the specific issues that are raised under section 149, which are quite specific when you actually look at them in detail, and they should be considered in that way, rigorously and with an open mind. Yeah,
and not just generically in general, not just generically, but applying it to specific issues arising in the area and arising under the policies. I would have thought. So in some areas, I think one of the examples in one of the questions we've had is protected characteristics of retired military personnel and rural disadvantage, which can arise in some areas but may not be at all relevant in other areas. So it's a case of really knowing your evidence base and your population characteristics, I suppose. What about is there any? Can we help decision makers and developers in terms of undertaking an equalities impact assessment when you're making a planning application or considering a planning application, and particularly when you're in like a case that Kim and I were involved in. So when you're having to relocate a small community. Is there any guidance as to how to undertake that assessment? Any kind of good practice, best practice?
And I think as Alex said, the courts aren't prescriptive about how you comply with the duty. As long as you had regard to the right things. I mean, I think the first thing is to consider whether you do need to get an expert in to do that assessment, independently. So in our case, Jenny, obviously the local authority had done an equalities impact assessment before making the decision, and we as a developer went and got our own expert evidence on that to put before the inspector to make sure that the right evidence base is there, as well as the sort of legal analysis. That it's making sure that you've got the evidence so that you can show that you have considered the right things robustly and thoroughly.
Yeah.
I don't know in terms of, I know there was a question about whether there's a sort of a structure for a decision that we can give. I don't think there is, because it will vary so much depending on the context that you're considering it in, and there is no prescriptive way of addressing this. But just make sure that I agree with Alex entirely. If it's raised, then I would just put it in your decision, even though you don't have to expressly say that you've considered it. Say that you have, and then say how. And hopefully the case law that we've referred to will give some guidance on the nature of the things you need to be taken into account.
Yeah, sure. And I think when you get to appeal stage as well, it's quite important to make sure your assessment's up to date, because obviously the makeup of that particular community can fluctuate, and there may be different concerns that arise at the appeal stage that just simply factually weren't there a couple of years earlier, maybe, if it's taken a long time to get through the decision-making process. Let's have a look. What time is it? We've got a couple more minutes, I think. just having a look at some of the questions. Another question we've got about disabled parking spaces. If they're provided, it says disabled parking spaces included and provided in purpose-built flats. If they're later designated as visitor spaces by a management company to be used in conjunction with scratch cards issued to all residents, does this breach the Act and how can it be remedied? So a changing position. You've got the planning authority who's obviously considered the needs of disabled residents and visitors. Those are then repurposed later by a management company. Is that a breach of the Act? I suppose the first question is, does the management company is the public management company subject to the public sector equality duty? What are your thoughts on that?
This is a bit interesting because there's almost parallels with our case again, Jenny, about the interplay between sort of landlord and tenant or other areas of law and what protections those areas provide for people versus the public law duties. I mean, here, the management company, unless it's a local authority that's managing this building, there's a private management company, they probably don't owe, they're not exercising a public function here, they probably aren't bound by the public sector equality duty, but there's maybe a question about the conditions to this planning permission that's allowed this to happen, or the Section 106 agreement that this has been granted without protection for the disabled parking spaces, and whether that's a potential ground of challenge for but it's probably an out-of-date challenge, out-of-time challenge, but if there's ground for challenging the original permission on that basis.
Yeah, and I suppose it's whether the management company owes, is undertaking any public functions, whether you could squeeze the management company into being subject to the public sector equality duty. I'm not off the top of my head aware of any case law on that. Anyone else? I'm not sure at the moment, but obviously with judicial review, generally that has expanded to cover, to go beyond the pure public bodies, but I'm not sure about that one. Just something on the rights of the child. Alex, Shattock probably. What about can an adult disabled child who's still cared for by parents, despite being an adult, still be covered by the UN Convention?
I'm not sure about that. I suppose if they're an adult disabled, they've been adult disabled man or woman, presumably, whom they may lack capacity, and they may have quote unquote mental age of a child, but they'd still be an adult, I think. So there'd be other duties that would kick in regarding disability, but I don't think they'd strictly be counted as a child.
I agree.
Go on.
I don't think you'd rely on that, would you? You'd rely on the other, the protected characteristic of being disabled and the Equality Act in that respect. Yeah. Okay. I think that's all we've got time for. I'm just going to have a quick look, see if there's a quick one left over that we could move on to. Yeah, just Alex, just on your toilets subject. We were a bit short of time and you rushed through a little bit, the changing place toilet. Could you just explain a little bit more about what that is and what it's intended to, what needs it's intended to meet?
Yeah, certainly. So it's basically a larger toilet, and it's for people with profound and multiple learning or physical disabilities. So it could be doesn't have to be physical. It could be someone with dementia or Alzheimer's who perhaps needs to be coaxed a bit or needs more assistance to use the loo, needs someone else in the room. Could be people with, say, muscular dystrophy, neuromuscular conditions, cerebral palsy, acquired brain injury, multiple sclerosis, anything like that, really, where you basically need more space and potentially more kit to actually sort of use the loo. And if there's not that kind of facility available for you and you wanted to go and, say, watch a football match, you might not be able to go unless that facility is in place. So that's why it's there and that's why it's important.
And I suppose it also has a slightly dual function of being a bit of a refuge, a bit of a safe place, just to take a bit of time out. Some of those people might need in a sort of busy public space. So, yeah, okay. Well, I think we'll end there today. So thanks so much, everyone, for attending and for staying on right to the bitter end. We've had quite a lot of questions, so we will just check through at the end and see if there's any more we can follow up with. But thanks for coming, and thanks to all the speakers for really, really interesting and stimulating talks. And we'll hope to see you again soon. Thank you very much.